Welcome back to Canadian Justice, where we're discussing psilocybin, or hallucinogenic mushrooms, their medicinal and therapeutic uses, and a new legal challenge. So, Spencer, in the last segment, we were talking about the patients who have brought this legal challenge. And one of the things this challenge involves is the exemption system that allows psilocybin to be used for therapeutic or medical treatment. How does that exemption system work? Or how is it failing to work for these patients?
Well, it certainly is. There are huge challenges. So I'm going to say that there's two main ways that can be used. The first is Section 56, which these patients have been using for the last 2 years and through help with their doctors. And it's essentially asking the Minister of Health, presently that's Jean-Yves Duclos and Dr. Caroline Bennett, for an exemption to the laws. So it doesn't actually allow the patient to get, GMP, produced psilocybin. It just says that for this person, the laws around psilocybin use do not apply to you. And that's difficult. Imagine having to reach up to the highest level of government to ask for permission for your medicine. So that's been incredibly inefficient. The minister has delayed some of those exemptions over a year. So ignoring terminally ill cancer patients, that's unconscionable. That cannot be happening. And so the government did allow for a second pathway called the Special Access Program. It's traditionally used to get patients access to drugs that aren't approved in Canada. Usually that's used for cancer patients or AIDS patients, but they've allowed it for psilocybin access. And in that case, for a psilocybin drug product that's been manufactured and has a certain amount of clinical data on it, patients can get access through their doctor. And so the doctor has to fill out forms explaining why they want this special access. But the first form that was filled out took about 3.5 months, and other forms have been taking, weeks for access. So as far as we're concerned, its results, the actual results of the program are a total failure. Patients are still dying before they're getting access. There's too much red tape. Doctors aren't sure what their legal capabilities are, whether insurance covers this. It is a complete and total failure.
Yeah, and I understand if you're a palliative care patient, you don't have years to spend dealing with bureaucratic red tape if you've been diagnosed with a terminal illness. Paul, you have brought a constitutional challenge to this regime. What can you tell me about the challenge? Is it a challenge to the exemption program? Is it a challenge to the criminal law? And what is the right under the charter that's engaged here with this system?
So first of all, we're challenging the prohibitions on psilocybin, the prohibition on possessing, growing, and sharing psilocybin.
That's the criminal prohibition.
Yes, the one you mentioned earlier, under the Controlled Drugs and Substances Act. We're also asserting that the exemptions that are available are unconstitutional and not providing reasonable access. And the section that we're relying upon is Section 7 of the Charter, which provides for life, liberty, and security of the person, and not to be deprived thereof except in accordance with the principles of fundamental justice. The key principle of fundamental justice is arbitrariness. So essentially, we're saying you're denying patients their liberty because they could be put in jail, as well as their under security. The person includes the right to make important personal decisions, such as how are you going to treat a serious health condition. The law here has been thoroughly developed in the context of cannabis. And so if I was going to boil all this down to a very brief statement, I'd say patients are entitled to reasonable access, and they are not getting that.
Just quickly, Paul, what's the timeline for the case?
The pleadings are in. Our statement of claims has been issued. We've got their defense. We filed our reply. We're probably looking at 12 months until the end, but there's a lot of variables.
Spencer, in addition to this patient-focused claim, which involves, as Paul mentioned, one health practitioner, there's also a judicial review related to Health Canada's decision to deny dozens of healthcare professionals' applications to use psilocybin for professional training purposes through the exemption system. What can you tell us about that case? We've got about a minute.
Yeah, we've got over 100 healthcare practitioners that are, quite frankly, they're upset that Canada, or the justice system, or the minister, quite frankly, has created two classes of healthcare practitioners. The 19 that got access to use psilocybin under Section 56 for training so that they could treat their patients, and then these over 100 healthcare practitioners who were denied access. they're upset because it seems as if there was a precedent set here that healthcare practitioners, like patients, should be able to train with psilocybin before they're giving it to their patients. But by denying these exemptions, the minister has created two classes of healthcare practitioners, and it doesn't make sense. So we've got some lawyers working on a judicial review there, hoping that the minister will reconsider and grant those exemptions, which are urgently needed so those healthcare practitioners can treat their patients.
We've got to go to break, but we will be right back to continue this conversation.